May I be permitted to mention a matter, my lords? Yes. Because there is item 30, which is a section 36 petition on your lordship's board, and an item 72, which is a section 34, my lords. I'm just requesting if your lordships would grant me the indulgence of some day, my lords. These are fresh matters. The urgency is that the tribunal has decided a substantive issue allowing a third party to file claims against Damodar Valley. Because I am for Damodar Valley. The hearing is fixed on the 29th. And my petitions, my lords, there's an interim award against me in this, holding that the third party who's not a party to the contract with me can maintain these claims. I'm just requesting any date which is convenient to your lordships, my lord.
Sorry, why should I?
My
What
lord,
is the reason for this? You have a 36, right?
my lords, a 36 and a 34 as well, item 7.
You have a 36 too and a
34.
So 34, obviously, I'm not going to hear it. I'm not going to give any precedent to it. Whenever it comes, we'll take it up.
My lords, my
And
only,
as far as your 30 is concerned, we'll see it.
my lords, any date which is convenient to your lordships, my lord, that's what my humble request is.
No, sorry.
May please.
Could it be on Thursday if it's suitable to the
Not possible, sir. Sorry.
Very well, my lords. I'm grateful.
My lords, I'd like to mention a matter, my lords, in the list today, my lords. Item number 61, my lords. It was listed on Friday, my lords. Had asked the other side to.
It's running in the list.
My
This is
my
the
lords, I
first
understand.
34 petition. We'll hear it.
My lords, item,
Whenever it comes.
my lords, because my lords,
Whenever it comes, we'll hear it.
it's a section 34, my lords. There's
Yes, I know.
urgency in.
ये गोपाल 34 और किस दिन रखा हमने? Thursday 3 p.m.
My lords,
We'll-
Thursday, there's.
Thursday 3 p.m. we'll take the 34 petitions in serial wise. All right.
Great.
May I please your lordship, my lord. May I have your lordship's kind leave to mention my section 11 for inclusion. My lord, the pleadings have been completed. Affidavits have been exchanged. This has not appeared before your lordship earlier. This is of 2025 AP. My lord, it's only for inclusion, not in the list, my lord. Any day, my lord, your lordship, please. Sir. Grateful.
My lord, may I permit to mention a matter, the education matter has been settled between the parties. Now the warrant is pending, but I want that it discharge the warrant as urgency, my lord.
Keep it tomorrow.
Subject to pleasure and convenience of your lordship,
Yes, sir.
may I mention a matter
Yes, sir.
upon notice to the other side, my lord. It's a matter whereby, pursuant to the order passed by Honorable Justice Shampa Sarkar on 7th May 2025, whereunder his lordship was pleased to appoint Mrs. Mohua Dotto Bishas as a receiver to take the possession of the hypothecated asset, that is excavator, and that was carried out by the learned my friend and receiver. Thereafter, my lord, may I hand up the
Tell
copy
me
of
what
the,
is it? What do you want?
my lord, your lordship was pleased to pass the order for making over the remuneration to the learned receiver. But ultimately, the petitioner willfully neglected and deliberately failed to make over the remuneration to the receiver.
You are the receiver.
My learned friend is the receiver. Mohua
Who are you?
Dotto Bishas.
Who are you, sir? Who are you?
I am
Yes.
her advocate and
No.
counsel.
You are the petitioner. Who are you in this matter?
I am on behalf of the receiver, my lord.
On behalf of Mahua,
Mohua.
Datta Majumdar, whatever. Please,
Yes.
sorry.
My lord, mention
Yes.
My lord,
Yes.
it is
No, sir, I'm not hearing you. Yes. Ask the receiver to come and appear in the court.
lordship. Lordship.
What kind of practice is this? Receiver sends a third person to mention a matter that she has not been paid the remuneration. God knows where do you come up with these
Lordship,
kind of
lordship.
practices.
I shall direct.
Who are you? Have no locus to mention the matter. You're not connected to the case. Are you the receiver?
No, I am.
Are you the petitioner? Are you the respondent? Who are you? Rank outsider to the case.
I have been directed by the.
What do you mean directed by them? Who has directed you? The receiver will direct you. What kind of practice is this? Please, sir. Yes, yes, Mr. Banerjee.
Malad, kindly excuse me for the. I beg to be excused, my lord, and I shall ask the receiver to come.
You are nobody, sir. Please understand. Can a receiver appoint a lawyer to mention a matter? Please.
May I have a lordship's time?
Yes.
The lordship has already told us that the section 34 applications will be taken up on Thursday. That these are two matters running in the monthly list. We are indeed keen to proceed with our hearing.
I want to hear the 34th.
May
So,
we given some
which year? Award of which year? Award of which year?
2023 and 2024.
Wait. Let me deal with the.
My lord. Something because we are keenly interested to finish off. Not a very big matter to discuss.
All right, give it.
Let's kindly
My
to
lord.
mention a section 11 application of 2022. Matter was never 11 application of 2022 matter never listed after exchange of pleadings. So,
My lord, may I mentioning for restoration application, copy has been served to the other sides.
My lord, may I be permitted to mention, my lord, a 34, my lord, in a worse situation than Mr. Banerjee 2018 award, my lord. That's the only issue, my lord. My lord, 2018 award insurance claim of
Yeah, we'll
2000
see if we can.
deeply obliged. That would be. It's in the monthly list.
Also, maybe permitted to mention some matters for withdrawal.
Listed matter, application for ruling in contempt, item number 1.
No, this is the application which I moved on Friday. I'm only asking, praying for lordship leave, so that we can serve the respondents and come back. The lordship's order is of 18 June.
You're asking me to literally issue a notice
No,
on the contempt.
No, not rule. I'm not asking for rule. What is, we are undertaking the metro railway work, and the other side is the railways. The lordship order was that the learned.
There's a contempt. What kind of
The compliance of lordship's order is at 18 June, starts at page 13,
What is
and the operative portion is at page 15. They have only the balance amount of 5.82 crore is left to be paid. Otherwise, they have also paid us
minor recovery proceeding. What is the contempt?
contempt. They have not paid the amount in terms of the order passed by this court. Lordship, see page 14, the last two lines of page 14. Accordingly, the award debtor is directed to pay the award holder the balance amount, which remains payable. The balance amount is still unpaid, 5.82 crores. They have only paid us rupees 79,71,000. And we have already given them notice, which is at page 23, that you have, and the charge.
Your application, which I have read, the amount was released in the application, right?
Yes, that amount has come to us, which was lying in the court.
This
That has
is what the application wanted and nothing more.
No,
The dispute
lordship,
rate is-
kindly see,
Sir, this is no. To do with the order of the Banerjee.
kindly see page 14, last two lines.
I see
There were
that.
two
This is
components.
only the mistake is that I have been more benevolent
No,
to
no,
you
there's
and
no
you're trying to
mistake.
take advantage.
No,
of
I will not do
Nothing
that.
else.
Lordship, we are the last person to take advantage.
nothing
Lordship,
more.
the amount which was lying in with the learned
That was
registrar
the
was only
application.
20. That
Your
was,
GA was only for that purpose. This is the same matter.
no, not for that purpose only. Lordship, 29 crore was lying with the learned
You
registrar.
wanted release of that money.
That we have
Which
got
was
with interest, but the entire amount under the award has not been paid. That was a portion of the awarded amount.
Your application was only for the release of the money, not for
As per the
payment of
award.
yes.
As per the award. Lordship, may I come back with that application which Lordship had passed the order? The prayer portion of the.
Please show me that.
Yes. Kindly keeps it tomorrow. We shall come with the application also. Wherein this order? Thursday, Lordship kindly keeps it on Thursday. My lord, we have annexed the chart. Kindly see the chart, which is at page 22. When
Show me the application.
that application is not annexed here. We will come with that application to show you the prayer. And the chart we have given, the learned registrar has given us the amount. They have paid amount of 17.9 lakhs. The balance 5.82 is left under the award.
In the event the award debtor fails to make the balance payment within the aforesaid period, the award holder shall be entitled to take appropriate steps in accordance with law for enforcement and recovery of the same.
Yes.
That can't be a contempt petition.
No, that I have judgment to show that I will not, as an officer of court, I will not. That I've got I've armed with the authority which says that the Honorable Apex Court has said that for this contempt is also maintainable. I've got the hard copies here and now.
Show me the application. You're just taking.
Yes, that I will
You
come.
are
Lordship
taking
keeps it on
advantage of
Thursday.
the order passed.
No,
You're
Lordship has not committed any mistake.
Yes,
Neither I am taking any advantage. I will come and show you. Lordship kindly keeps it on 29th, my lord, Thursday. 28th we have a holiday. 28th. Sorry, 28th. Sorry. Sorry, 27th. I'm so sorry. Thursday, my lord. 27th.
Thursday it can't be. 28th.
20th, my lord. I'm grateful.
Motion section 29A, at not 2.
May it please your lordship, Lord, this is my application. Lord, under section 29A of the Act.
So my
Lord.
learned friend starts, my lord. This is 29A application.
Sorry?
This is a 29A application, my lord. I'm appearing for the respondent number 4 and 5.
Yes.
My lord, this application perhaps, my lord, is not maintainable if your lordship because
Not maintainable. Why?
because my lord, this lord, my lord, High Court, my lord, is not the principal civil courts, my lord, under 29A, my lord.
But there is already kindly come, Millard. I'll address this. Please have a look at page 16, Millard. We had already approached this honorable court
No, but after
for
the judgment of
substitution.
Judge
Size 42
Chowdhury,
will
my lord.
apply. We had applied, Millard applied before this honorable court for substitution on an earlier occasion.
That's all right. But after that judgment of the Honorable Supreme Court, whether this court is the principal civil court under 2E
Millard,
or not,
that's certainly,
has to
Millard,
be
if your
seen.
lordship feels so. But Millard, we have already
I
approached this
don't
honorable.
think so. That is the
We have
objection
already
which-
approached this honorable court, Millard, once
All
earlier.
right, Mr. Banerjee, you know it.
Yes, yes.
Initially, I was also passing those orders.
Yes.
But subsequently, we are not.
Yes.
In terms of the Honorable Supreme Court's order of Justice Narasimha,
Yes.
we are not passing those orders. You have to
Millard,
go before the city civil court or
29A
whichever the court is.
29A, Millard, will either be, Millard, the principal civil court. In fact, it has been clarified, it has to be the principal civil court.
Correct.
However, if we have already, Millard, approached this honorable court, then under section 42, Millard, this honorable court has the derivative jurisdiction. And we have a
Then
look at page
let him
16.
file his reply. We will have
That is
an argument of-
clarified by the judgment itself, my lord. My lord, paragraphs
It is very
Millard,
clear.
30 onwards, my lord.
Very well, Millard. I don't think so. There is
Kindly
any
look at it.
requirement of an opposition. I will argue the point of Millard, section 42. I do not mind going elsewhere.
My
It is
lord,
just that,
Take his affidavit on record, then I'll pass an order.
as your lordship feels, Millard,
my lord,
a short affidavit. If my learned friend can give me this.
How can the Alipur court refer the matter?
No, appointment was from here.
Appointment has to be from, sir, what?
And then, Millard,
Who has the power under section 11? Who has the power under section?
Milord, initially section 11 application was filed, Milord, and this, Milord, affidavit was appointed. And when, Milord, this application was, substitution was, Milord, taken up, then I took a preliminary objection that the substitution application in this case, Milord, is not maintainable because the same procedure has to be followed, which was procedured in the first instance by the first affidavit was appointed. So, Milord, the Honorable Court on the last occasion invoked the provisions under section 11 as well. And so once section 11 has been invoked, this cannot be treated as a ground that earlier this court was not approached and the principal Supreme Court will be on. I also intend to file an opposition.
You have the same objection.
More or less, and also one thing, incorrect statements have been made that.
See, Mr. Banerjee, whether you want to file it here or not.
Millard, I will have to check that.
You
Millard,
check that up and
check
come
it.
back.
I'll have-
Otherwise,
because I understand arguments for sections 14 and 15, that Millard, it is different.
My lord, it has
If
been
I have-
clarified by the
problem
Supreme
is-
And
Court.
Millard, the judgment is there.
My lord,
judgment
it has been
is
clarified by the Supreme
slightly wrongly, whatever it is. Today, the judgment is there, right?
Yes.
But if your lordship gives me just 30 seconds, judgment is on 29A.
So we are
I
only
am
con-
on 29A.
We are only
I can
concerned
only
with-
argue 42 if it was an application under section 14, not under section
been
15.
taken
As it
Banerjee,
appears,
you
Millard,
can argue anything. That's not the point. The
Yes.
point is, please go and see if this application needs to be filed here or before the. whatever
yes,
the
principal civil court. I'll check that judgment once again when my lord.
Come back.
Section 42 has been taken
Otherwise,
care
you
of,
want
my
to do this exercise, I have no
lord. I
problem.
understand.
Let them file their reply. Your
No, now I'm feeling that perhaps some other court. Because what had,
it's a waste of time.
yes, and Milord, I had approached the court under
Because
15
the whole
earlier.
purpose is that you want an extension.
Yes. Milord, can your lordship keep this matter tomorrow?
Tomorrow?
Please.
Not
I'll
today.
just look at the judgment.
Or
And
tomorrow, day after.
day after tomorrow. Milord. Oh, Milord, then Thursday.
Friday.
No, Friday I'm not there, actually. Then next Monday.
Next Monday.
Next Monday. I'm obliged.
Otherwise, I think you have to go before the.
I'll check that up, Milord, and I'll address your lordship quickly on that.
New motion of section 11, item number 3.
For the respondent, my lord, we have already filed the affidavit in opposition, my lord.
Who's for the petitioner?
Your Lordship, I am for the petitioner in this matter. I was praying for Your Lordship. Your Lordship, I am for the petitioner in this matter. I was praying for time to file the affidavit in reply.
You have pasted your picture.
Your Lordship, I am not well. That is the reason I'm not in court, Your Lordship.
All right, not today.
Now 4.
Lordship, I'm appealing for the petitioner.
Lordship, I appear for the respondent in this matter. I had filed my affidavit in opposition on 15th of July. And on 24th of July, your Lordship had granted the petitioners further 2 weeks' time to file the reply. However, we haven't been served.
We are filing the affidavit in reply today.
You have not given a copy to her.
No, today I'm filing.
At least.
I beg your pardon, Lordship. Lordship, I'm being led by Mr. Shilon Sengupta in this matter. He is out of station for his personal reason.
Learned counsel for the petitioner affidavit in reply to the affidavit in opposition filed by the petitioner is taken on record. Copy of the same has been supplied to the learned counsel for the respondent. Learned counsel for the petitioner states that he's been led by Mr.
Shilon Sengupta.
Some personal difficulty. He prays for an adjournment. Let this matter be. When do you want?
After a week, yeah.
Next week.
Next month.
Section 11.
Section 11, Your Lordship.
What is the opposition?
Your Lordship, the opposition is, I am saying that they are relying on an agreement which was never executed by me.
Not signed by you.
Not signed by me. That is my case.
Monday?
Monday, Your Lordship. 31st.
Much obliged.
Your Lordship, may I?
Next one.
May I only pray my advocate on record is in some difficulty on 31st, any other day, Your Lordship.
Okay, Wednesday?
Wednesday, Your Lordship.
Wednesday.
Second.
Gopal.
Wednesday.
Sorry.
I'm grateful.
Much obliged.
Take it. Second September. 5.
Yes, madam.
Lordship, on the last week you asked me to bring the order passed previously in similar matter.
No, but these are matters in which no payment has been made.
In this matter, the payment has
Been made. Okay, which matter? Item 5. Show me. Show me that order. You have made the corrections.
Lordship, SOA is at page 74.
Page 74.
The assignment was done in 2021.
Yes,
But the last
just
week,
a minute. Just a minute. So according to the SOA, the due amount is 66 lakhs. Crore.
yes, after the interest.
All right.
Last amount was received on
When?
2nd July 2022.
Where is that serial number?
28.
And this is to the assignee.
Yes, Lordship. After the assignment, the amount was.
So he has been making the payment, the earlier payments also. To you.
Earlier, the payments were made to Shay. Then assignment was made in 2021. Even after the assignment, the payment was made to the assigned.
Which is on 2nd of July. Right? Show me that order. All right. So this will be this fine. Yes. कौन है इसमें दिखाना?
Six.
Lordship, in this amount, there has been no collection installment. And
Yes. So
it just let the issues be kept open.
that issue can't be kept open. Then they are not signatory. They have not. The assignment will not help us.
Lordship, but this intimation letter was issued.
Intimation letter will not help. That's the reason why I asked you that. How do you to invoke 11 will be difficult. You can file your recovery proceeding or something. That's why I asked you to take instruction regarding this.
Lordship, they have been informed through demand notice.
That's all right.
and
But
section-
unless until they act upon the assignment, we can't say that they are assignments. They have not acted upon it. The only distinction which is there in all the other cases is they have made a payment. So they have recognized you as an assignee.
Yes, Lordship. Then Lordship, I
In these matters, they have not. That's the reason I've been pushing it and asking you to take instruction. Because 11 will not be then maintainable. Then you file your recovery proceedings.
Lordship, I'll
To take instruction, that's the reason I've been very candid about this. Otherwise, I'll dismiss all these 11s.
no, Lordship. I shall satisfy you.
You satisfy me on this, on the assignment clause.
Yes, Lordship. I
Get me the judgment.
yes, Lordship. I'll get the judgments.
When do you want?
Sure. 3 weeks.
3 weeks?
2 weeks.
2 weeks. After 2 weeks, keep it after 2 weeks. Learned counsel for the petitioner seeks an adjournment. Just after 2 weeks. This is item number 6, 7, 8.
Lordship, in 7, the payment was made.
Made? Sure. Page? S-way?
Page 73, Lordship. Assignment was made in 2021
Yes.
and the last receipt was on 19/4/2022.
Serial number 12.
Yes, Lordship.
In this, do you have the order?
Lordship, I have not made the corrections.
After 2 weeks. This, so 7 will be seven and 8. What about 8?
Lordship, no payment.
No payment. All right. 7 and 8 after 2 weeks. 2 weeks. 2 weeks. 2 weeks.
7 and 8? 6, 7, 8?
6, 7 and 20.
Hindi order.
And on 9. My lord, item 9, 10, and 11 are my applications, my lord.
Yes.
For appointment of another arbitrator, since one of the early arbitrator has now, my lord, withdrawn from the references.
How are you placing out a record? His withdrawal?
My lord, it has been, my lord, withdrawn during the pendency of our section
Right,
14.
but are you placing out a record by a supplementary affidavit?
We'll file a supplementary affidavit.
How do I take it on record?
Earlier, my lord, what used to happen was that, my lord, copies were also given to the registry, and the registry used to
But that practice is
understand.
over.
Understand.
Back.
My lord, we'll file a supplementary affidavit. Kindly grant us, my lord, leave. 2 days.
Next week we'll have it.
Yes, my lord. Kindly keep it on Monday, my lord. In the meantime, my lord.
Then I'm not passing any order. You file
Very well.
your supplementary. We'll take the supplementary. Not today.
Monday.
So that I can take it on record and pass an order.
Yes, my lord. Great.
You have no objection?
No.
Then we don't go into the mandate and other things.
Yes, my lord.
We just simply on the basis of this the letter.
Yes, of course, my lord. In fact, your lordship was of the view that we must avoid, my lord, making any submissions.
Exactly.
That's when I spoke to my lord, the learned
I
arbitrator.
just want the letter to be on record.
Yes, my lord. We'll bring it by way of a supplementary affidavit. My lord. We won't be pressing any of this. And not 10.
9, 10, 11.
9, 10,
all
and
3
11.
matters.
No, sure. And not 12.
Chip, I'm for the petitioner. I'm led by Miss Manali Ali. She's not well. So I'm seeking for an adjournment today.
Not today.
Well, it's in item number 13. I am for the petitioner. This is my section 11 application.
For Union of India.
We have served the respondents twice. We have served.
That's all right. Union of India, you know, there's a panel, or you can serve upon the ASG.
Then I can serve and again serve and come.
Anybody who's on the panel of Union of India here? Serve them again. Who are you serving upon?
Well, it's the railways actually. Railways and
Serve the council also. You can take instruction. Somebody was here, I would have. Not today.
They are in the panel, but I heard that in next month, my lord, the panel might be reshuffled. So,
but today you're there.
Yeah, they are in the panel.
You take instruction.
I'm serving.
6 and 11.
Give the file.
Already arbitration is not under dispute, Millards. The railways has
Take instruction.
Yes,
He has to
please.
take the file. There's an application filed by the petitioner seeking appointment of a sole arbitrator to adjudicate the dispute and differences that have arisen between the parties. None appears on behalf of the Union of India. Respond number 1, respond number 2. But you have to serve upon the respond number 2 also.
I have served, my lords. Respondent 2 also.
Union of India, I can understand.
And second is DRM, Divisional Railway Manager.
DRM will be, that won't be under the Union of India.
But DRM is also under.
No, sir, Union of India, even as far as the general manager is concerned, you have to
Actually,
check.
they won't come under directly under Union of India. Railways has a totally different panel, my lords. That's why I have served the headquarter, and
That's why you're not getting anybody.
that's the problem.
You serve them again. Chodo isko. Serve them again. And please see if it is Union of India or the general manager.
It's general manager, my lords.
General
Then why have you made the Union of India party?
Under the Railways Act, Union of India through general.
To general manager, that's right.
Serve them, serve them.
If my lord is being pleased to direct me to appear in this matter,
Not in this. Let him serve.
let him serve. Then.
Not.
My lord, in item number 14, my lord, I am for the petitioner, my lord. This is my application under section 11. However, my learned friend on the last occasion has said that, my lord, his client wants to go to mediation. But I have taken instruction from my client in this regard. And since my learned friend is there and I am there, my lord, my client is of the opinion if myself and my learned friend can sit together, perhaps the matter can be
Let
resolved.
us go before a mediator. I have also
No.
thought of, let us go before a mediator. I
Please,
think
my lord, please don't send us before a mediator. My learned friend is competent enough. Myself and my learned friend can sit once
a lot of
to
things. Let us
get
be
it
before a
resolved.
mediator. I think it will be settled.
Otherwise, my lord, it will be a complete wastage. As I know them, my lord, they sit and thereafter, if they don't
let it-
agree, then I will be, my lord, again.
No, let it go before the mediator. Both of you can extend your, good officer services before the mediator and get it resolved.
Both of us will
He is
be
not
there.
inclined.
My lord, my instruction is that, my lord, if my lord, my learned friend and myself, my lord, try to attempt it to mediate, my lord,
your
then they are
learned-
agreeable. Otherwise, my lord, it will be again, my lord, bearing the cost of the mediation, and thereafter
What cost
again I
of
have
the-
to come before your lordship. If they are,
If this can be settled, a lot of cost can be.
so if they are really,
This section 9, this section
yes,
11.
yes, it can be settled with your intervention and my intervention. If your client is really wanting a settlement.
Let us
Go before the
go before a.
mediator.
Lord,
Right.
kindly don't send us to mediator, my lord. Let us, my lord, sit together, my lord. Kindly adjourn it for, my lord, 10 days, my lord. Let us try to resolve it together. Otherwise, my lord, there will be no point, my lord. Only my section 11 will be delayed.
Effort has been carried out by the advocates, what I have been told, my lord. Let us be before a mediator, my lord. We will be there.
Lord, my learned friend is so sure about the failure of the mediation that he don't want to be the mediator.
Not about the failure of the mediator. He says a lot of effort has already been made between
Yeah,
the
oh,
parties.
sorry, my lord. I heard wrong. Heard wrong.
But lawyers have tried.
But in that effort, my lord, neither my learned friend was there, not
being
myself
there,
was there. But I
sorted
believe,
this
my lord, both of us can do
simple
the
issue.
needful.
He has
my
a lot
lord.
of faith in you.
Yes, yes. We have
His
done
client
matters together, my lord.
Let us be before a mediator.
You come back next week.
I can do that, my lord. But
Today is Monday. You come back on
but
next
then kindly give us more time, my lord.
Next
because
Friday?
My client is based in Durgapur.
next Friday.
Friday week.
Not this Friday. Next to next Friday.
Friday.
Friday week, Lord, if we can resolve it by that time,
Not this
Lord, then
Friday.
it's-
Next to next Friday.
Yes,
But
Lord.
2 weeks, I don't
Friday
think
week.
this dispute can be. It will take time. That's the reason, my lord. I would have sorted before
If there's any progress, then we can.
as your lordship.
Yes, otherwise, my lord, your lordship can appoint an arbitrator, my lord. There is an undisputed arbitration agreement.
That application will come up under fraud and lot of other issues are involved. Then we
Yes,
can
yes. That I will deal.
Mr. Chakravarti, go before a mediator. That's much better.
Much
My
better.
lord, my lord, as I know them, my lord, going before
Let
mediator
us go
only
before a
will
special
linger
court.
the issue.
That is
They
what
will not
No, no,
agree.
no. A senior mediator will handle it. I don't see there is any difficulty in that. Learned counsel for the parties.
Lord, give us 1 week, 10 days time, my lord, because my instruction is, my lord, going before any other mediator, my lord, they are as such not consenting to that, my lord. That is the difficulty.
Then you argue the
They-
matter, you file his reply.
Yes, sir.
I'll file my opposition there, my lord, if he is not agreeable to it.
My lord, my lord, this is, my lord, arising out of a, my lord, development agreement, my lord. It's a registered development agreement dated 3rd of January 2024. And my lord, your lordship can straightway come to the.
Mr. Chakravarti, you don't want a mediation.
My lord, I want a mediation, but with the effort of the learned lawyers, but not before a mediator.
Why
because
only
that
the
will, my
learned
lord-
lawyer?
No,
Why not
that will-
somebody else? Why not a third party?
My lord, before a third party, my lord, it will only linger the issue because they are
How are you so
minded
sure?
not to settle. My lord,
How
my lord,
are
we
you
have, my lord, my lord, we have attempted, my lord. My lord, then, my lord, let me try to convince my client, my lord, kindly fix it on Friday, my lord.
We can go with the High Court Mediation Center.
We are not sending you anywhere else.
We are going to go with
No,
the High
that I know, my lord, but my lord,
If my learned friend wants to, I'm taking a point of
my
mention.
learned friend, perhaps, my lord, they are.
Instruction you were supposed to take, Mr. Chakravarti. What instruction have you taken? What kind of instruction is this?
My
That
lord, the instruction was that, my lord, both the sides lawyer will
you
mediate,
come
my lord,
back.
if they are agreed to that.
No, come back in 5 minutes. Get me the instruction. Pass over. This is no
Yes, my
instruction.
lord. Yes, my lord, yes, sir.
Oblige.
Next.
15.
Here for the petitioner. Security Captain today, my lord.
On the other side.
Lord, I filed the affidavit of service, my lord. I see, my lord, all have been served except, my lord, respondent number 6, my lord. Although, my lord, I have the envelope, my lord, and the address is same as that in the agreement, my lord.
Problem.
My lordship will kindly come to page 30, which is a part of, my lord, a development agreement.
Wait a minute. Service has to be done on everyone.
I'm sorry.
So who's not served? 5 or 6?
6.
Learned counsel for the petitioner seeks and is granted.
My lord, the only issue is, my lord, I have served on the address that's there in the.
Whatever it is, served.
Sir, once again.
Yes. States that affidavit of service taken on record. Affidavit of service indicates that respondent number 6 has not been served. Learned counsel for the petitioner seeks and is granted 2 weeks time to effect service on respondent number 6. Full stop. List after 3 weeks.
Lordship has kept it on.
After 3 weeks.
So so that's the only address that I have. So I'll attempt once again on the same address.
Get the new address, old address. I'm not concerned. Serve.
So,
that's insufficient address. So obviously you have to get.
But there's the address that's there in the agreement. I cannot have that's the address that the party himself has given. And I am carrying, my lord, the original envelope, which has returned because.
Through substitution then.
I shall, my lord, attempt once again in that case.
Next.
Number 16.
Wait, please. This is my application under section 11. Service is complete. They have replied to section 21. That is there in the record. So wherefore it appears that they have admitted the arbitration, but they have disputed the merits of the matter. Now kindly comes to page 34. That is the reply to section 21 notice. In the reply, they have categorically disputed the merits of the matter. And page 37 to paragraph 26, 25 and 26. They are not agreeable to the named arbitrator which I have mentioned. And the agreement is at page 21. Thank you so much, Mr. Booth.
What is this agreement?
My
What
lord,
is the agreement for?
no, this is an agreement for putting advertisement on the buses, on the outer surface of the buses. Altogether, 460 buses are supposed to be given, but I am answerable to my clients. But ultimately, buses were not given. When I went there, I saw that someone else's advertisements are put there. When I went there, sometimes I saw that buses were totally, the body has been changed. There are several issues we have pointed out, and a demand has also been made. The demand has not been replied. They accepted the demand in spite of service, but they have not given a reply. But section 21, they have given reply, and they are not agreeable to the person named. Page 37, my lord, paragraph 25 and 26.
This must be, there must be a lawyer for State Bengal. Transport
Yes,
Corporation.
yes.
Serve them again.
My lord, may I do one thing? The person who has, my lord, given the reply to section 21, may I serve her?
No, serve the respondent.
Respondent, I have served, service is effected. My lord, in that case, my lord, kindly give a further direction so that I can serve with the order of the court.
Affidavit of service taken on record. None appears on behalf of the respondent. The petition is directed once again to serve upon the respondent as well as the counsel for the respondent who has issued the section 21 notice, who has replied to the section 21 notice given by the petitioner. List after 2 weeks.
Well, give me at least 10 days time, sir. 2 weeks. Mark.
And now 17.
I'm filing here with my affidavit of service and notice of motion. The respondent has received this, my application, on 18th of August, as it appears from affidavit of service, my lord. First of all, I'll take your lordship to page, volume 2, page 208, annexure II. Your lordship's order.
Page?
Page 208, volume 2.
Yes.
My lord, this is a statutory arbitration application under section 11. Under Surface Act, section 11, my lord, clearly
Madam,
says that if there is a
yes,
dispute
they were appearing all through in
on
that
last,
proceeding.
in first application they have appeared.
Yes.
Only objection they have taken is that no notice under section 21 was given.
So
now I have given notice under
very
section.
good. So serve them again. Let them come so that we can pass appropriate orders.
My lord, it's a huge record. May I be permitted to serve my letter requesting them to appear on next date to be fixed?
It's not a huge record. You are a bank. What is the difficulty?
It's a huge record.
You are a
If
rich,
you object, so please.
you are a rich bank, Union of India.
It's true bank, but it's a
Union Bank of India. Have they replied to your 21 notice?
I have filed affidavit of service, notice of motion, both.
No, have they replied to your section
No.
21 notice?
No. I have annexed my section 21 notice. Would you like your lordship to look into?
Oh, it's all right. Learned counsel for the affidavit of service is taken on record despite service none appears for the respondent. Learned counsel for the petitioner is directed to once again serve upon the respondent as well as
Your lordship may take up my section 11 notice,
the
page
counsel for the
203.
respondent who had appeared.
As your lordship got it, volume 2, page
It's all
2.
right, madam.
I've given a fresh notice again under section 21, and I have named
As well as the counsel
I
for
have
the
proposed the name of learned, name of sole arbitrator, requested them to give their consent, but no reply.
counsel for the respondent who had appeared in the earlier round of litigation in AP Com 122 of 2026. List after 3 weeks.
3 weeks. After 3 weeks.
Go to time delay to serve entire.
2 weeks, 3 weeks service. Yes.
I'm obliged, me.
If they'll come, maybe they'll consent for it. We can appoint the arbitrator. The reason why I'm asking you to serve upon so that they can give a consent. Probably the only objection which they had in the first round was the section 21. Now, since that has been served, maybe they'll give consent. It's a statutory appointment.
Yes.
No, 18.
Your Lordship, I am appearing on behalf of the respondent. I am under instruction to appear on behalf of the respondent. Your Lordship, in this matter, I am led by Mr. Gunjan Shah. In this matter, all I am praying for fixing the matter, not this week.
Who's for the petitioner?
Uh,
None for the petitioner. In the interest of justice, adverse orders are deferred. List after 2 weeks. Next week, let's start next week.
Item 14, I think my learned friend is there online, which item 14.
Yes, Milord. Yes, Milord, I have taken instruction, Milord. Milord, they are agreeable to go before a time-bound mediation, Milord, provided the matter is, Milord, kept pending.
Obviously, the matter will be
Oh,
kept.
yes. Milord, kindly make a time-bound reference, Milord.
What? No time bound reference. 14 में करो learned counsel for the parties. Submit that they are ready to explore the possibilities of an amicable settlement. They agreed for this matter to be referred to the mediation cell of the Calcutta High Court. Let this matter be referred to the mediation cell of the Calcutta High Court. A senior mediator should be appointed by the mediation cell to look into the dispute between the parties. Full stop. Let this matter be listed before this court after 3 weeks.
My lord, direct on the registry to intimate the same to the mediation center.
The registry is intimate. The registry shall intimate the mediation cell for appointment of a mediator.
Deeply aware.
The department shall be. The registry, the department shall intimate the order, this order to the mediation cell of the High Court to take necessary steps.
Deeply obliged.
Deeply obliged. Milord, we hope that it can be resolved.
We hope. Hopefully.
Yes.
And 119.
Lordship, I am the petitioner.
is the affidavit of service. It has been effected on the respondent on 21st August, Your Lordship, and notice of motion. I'm being led by Miss Lavanashri Sinha. She is online, Your Lordship.
May it please, my lord. Lordship, service has been effected on the registered office of the respondent. There is another address, Lordship, pleaded in the cause title. Over there, Lordship, service has not been successful, but the registered office has been successfully served, Lordship.
All right, yes, tell me.
Yes, my lord, the present application under Section 11 arises out of 3 purchase orders that were placed by the petitioner on the respondent. Lordship, the 3 purchase orders contain identical arbitration clauses. The contract was for the petitioner supplying raw materials and steel bobbins to the respondent, which the respondent would then convert into finished goods and fix on the steel bobbins. May I take, my lord, through the identical arbitration clauses at pages 34, 41, and 55 respectively. My lord, may kindly take page 34. Kindly takes clause 17 thereof, dispute resolution. May I place the clause, my lord?
Yes.
In the event of any dispute, difference, claim, or question at any time arising between the parties in connection with or arising out of this order, including any question regarding its existence, validity, or termination, within brackets dispute, a designated senior officer from each party shall promptly meet and attempt to negotiate in good faith a reasonable and equitable solution for such dispute. If parties are unable to resolve the dispute within a period of 15 days, arbitration under the 1996 Act, one panel to be appointed by Usha Martin Limited. Now, Lordship, coming to the first part of the clause, the petitioner noticed that raw materials worth around 34 lakhs were lying unfinished and unprocessed with the respondent, and several communications were addressed by the petitioner. May I take, my lord, to the correspondence of 13th April, which is at pages 57 to 60, Lordship.
Yes.
Kindly seize, Lordship. By my notice of 13th April 2026, I demanded the sum of money equivalent to the value of the raw materials and unfinished goods lying at the warehouse of the respondent. I followed it up, my lord, with a similar notice on 17th of April, which Lordship finds at pages 61 and to 65 of my application. Again, Lordship, similar demand. Now, Lordship, to this, there is a response which Lordship finds at pages 66 to 69. It is, my lord, the respondent's letter of 25th April 2026. May I briefly place that, Lordship? Kindly seize, Lordship. Lordship has found page 66 and the respondent's reply.
Yes.
Yes, kindly seize, Lordship. This has been addressed to the petitioner by one Mr. Jhavar, who is admittedly a director of the respondent company. Kindly seize, my lord. There is no denial of the fact that raw materials and unfinished goods are in fact lying in the custody of the respondent. What he instead sets up as a defense is that the 2 directors are allegedly engaged in a 241-242 litigation before the Honorable National Company Law Tribunal. Kindly takes, my lord, page 67 of my application, where the details of the alleged dispute between the shareholders is set out. May I place, my lord, the penultimate paragraph on that page? Further, in the interest of fair justice to all. That is the specific stance of the respondent, my lord.
Where's the 21 notice?
Yes, lordship kindly takes my 21 notice. That is 13th July 2026. Page 80.
It starts at page 79, your lordship.
Yes.
But there's a NCLT proceeding going on.
Lordship, the NCLT proceeding is in between the shareholders of the company, as the stance of Mr. Jhawar on behalf of the respondent reveals. There is no litigation pending between my client, the petitioner, and the respondent company. And in any event, Lordship, if I may place the reply to the Section 21 notice, there is a reply to my 21 notice that Lordship finds first at page 84. Kindly please.
Page 68, your lordship. 84 and 86. Page 84.
The first reply to my Section 21, Lordship, is at page 84, which is by way of an email from the same Mr. Jhawar, who had earlier responded.
Here he has sought time to reply.
Yes. Thereafter, Lordship, kindly takes page 86, which is the detailed response. Here, Lordship, two stances are adopted on behalf of Mr. Jhawar. Kindly sees, Lordship, the reply is not from the respondent per se, but from one of the directors of the respondent. The two defenses taken is that the arbitration invocation is premature because a mechanism of amicable settlement has been contemplated, which has allegedly not been first exhausted. And Lordship, secondly, unilateral appointment. Now, Lordship, in any event, the petitioner did not opt for unilateral appointment.
The present application has been filed under Section 11(6) of the Arbitration and Conciliation Act 1996, seeking appointment of a sole arbitrator to adjudicate the dispute and differences which have arisen between the parties arising out of the three purchase orders bearing number, यहाँ से लेना page 79 से, 1 dated so and so, 2 and 3. 1, 2, 3. Date भी डाल देना 79. Dated so and so, so and so, so and so. The petitioner had supplied steel bobbins and raw materials to the respondent for carrying out fixing and winding operation, full stop. According to the petitioner, substantial quantities of the material, including 55 steel bobbins, remained with the respondents and were neither utilized nor returned, full stop. The petitioner had made repeated reminders demanding the outstanding payment, the materials to be returned. None of the demands of the petitioner were fulfilled, leading to dispute between the parties. Full stop. Clause 17 of the respective purchase orders contains an arbitration clause in the said purchase orders. Full stop. The petitioner invoked the said arbitration agreement by issuing notice under Section 21 of the said Act dated 16 June 2026 and appointed Sayan Ganguly learned advocate as the sole arbitrator. Full stop. The respondent, by its reply dated 13 July 2026, declined to agree to the petitioner's nominee and inter alia questioned the invocation of the arbitration clause as premature for want of prior negotiation and not in compliance with the arbitration clause. Full stop. The respondent also counter-nominated Mr. Debapriya Gupta, learned advocate. Full stop. The existence of the arbitration agreement is not in dispute. Full stop. The respondent's objection regarding compliance with the pre-arbitral negotiation mechanism and merits of the petitioner's claims are matters which can be appropriately be considered by the arbitral tribunal. Full stop. The unilateral appointment mechanism contained in clause 70 having been disputed, the court is required to appoint an independent and impartial arbitrator. Full stop. The dispute arising out of the three purchase orders are interconnected and arise from the same course of dealings between the parties. Full stop. A composite reference is therefore permissible. Full stop. Accordingly, so and so is appointed as the sole arbitrator to adjudicate the dispute and differences that have arisen between the parties out of and in connection with the aforesaid purchase orders. Full stop. The learned arbitrator shall furnish his disclosure contemplated under section 12(1) of the Arbitration and Conciliation Act 1996 before entering upon the reference. Full stop. The learned arbitrator shall fix his remuneration in terms of the fourth schedule of the said act or with the consent of the parties. Full stop. All questions including objections regarding to the compliance with the pre-arbitral negotiation requirement and the claims and counterclaims of the parties are left open for determination by the learned arbitrator in accordance with law. Full stop. With the aforesaid direction, the present petition stands disposed of. Uske pehle line डाल देना. The copy of this order shall be communicated to the learned arbitrator to take necessary steps. Full stop. Who shall be appointed? How much is the total value?
Lordship, in inclusive of interest, just over 1 crore.
So, Mr. Banerjee, how many years you have put in?
More than 11 years.
All right. Mr. Banerjee is appointed. Learned.
I am deeply obliged.
Evidence of service. Despite service, none of them. ऊपर ही डाला.
New motion 20.
But 20 and 21 my lord, are related. But I have been briefed in 21. My lord, if my learned friend moves 21.
But it's actually conjoint. You know, from 20, we go into
on the part
21.
of your client. He's saving money.
Very unfair on me also.
You know, actually, you'll need to see 20 also because it's completely interconnected. In
So
fact, the defense in
start from 21, my learned friend can make the link in
We
20.
should have briefed you in both the matters.
it's not severable.
Not severable.
It's not severable. Let me,
Then
Lord.
we can come back tomorrow, my lord.
You know, I'll tell you, I'll just give him a
Yes.
short background and I'll tell your Lordship why. Maybe he can agree to the order. You know, 20 pertains to, my Lord, a lease.
Not Mr. Sen.
I'm sorry, my Lord.
Not Mr. Sen.
Not Mr. Sen. No, we'll get him to agree.
Let's see. To an arbitrator, yes.
Or to a conciliator. Commercial.
I know why my learned friend is giving this suggestion.
Why?
Section 7 proceeding is coming up tomorrow in the NCLT.
So I'm entitled to, my Lord, orders.
That adjudication is going on. Rather, my lord, there is an application which they have filed there that they are willing to deposit a certain sum of money.
Correct. I am billing here also.
and
You've
we
refused.
are opposing that, saying that, my lord, that is not the amount at all.
So very
And
good.
the NCLT is going to adjudicate that tomorrow itself. So, my lord,
Well,
these proceedings are only to preempt an order from my lord, so that the NCLT does not proceed.
No, I am openly, this is not a vexatious proceeding and I have legal rights. I've come with cases to show that orders may be passed for protection of the arbitration proceedings. To protect the arbitration proceedings, your lordship, under inherent powers, section 9 permits it.
Issue 21 notices in both the matters.
Yes, we have.
No, in one matter I am told.
Both matters we have.
Second matter, that there is a section 21 notice.
Now, I am not for once saying I owe somebody 10 crores, 20 crores, and I won't pay. I am here before your lordship to say that I'm ready to pay, but somebody doesn't want to receive the payment. And I'll tell your lordship how it starts. Let me just give a 2-minute background. There is a master lease agreement by which, my lord, 25 equipments were given, 21 were given to us. So, my lord, different payment schedules under, my lord, the agreement all 21 for all 21 equipment. No default, zero default. After the end, in terms of the agreement, I am entitled to exercise an option. Either they take back the equipment or I buy it off at a small sum of money, because by now I have already paid the purchase cost and I have paid more. So, my lord, it's a small sum of money. So in 2021, I say that I'll take. Now you give me invoices, I'll pay you. So they give me a figure in the course of meetings. The equipment are with me. They don't transfer it to me. I'm ready to pay, but they don't transfer it to me. So for 4 years, I can't use these equipment because by now, time has run out. I can't utilize it. I don't have documents, my lord, to use these in ownership documents. In 2024, I tell them that enough is enough. Either you tell me how much or you take it back. At which point of time they raise a pro forma invoice of 1.84 crores. I pay 1.84 crores. So give me the invoice, give me the documents now. They still don't give me. 1.5 years go by. I now come and say that, look, you're not going to give me the documents of title. I am walking out of this. 4 to 5 years, this equipment is lying fallow. So I'm cancelling. You take your equipment back, and 1.84 crores is to be adjusted with another agreement, with another loan agreement, which is the second matter. So this is the first matter. Now, my lord, so first matter, zero default. He is sitting on 1.84. I have not taken the equipment. So whichever way it is, I can claim 1.84. Now in the second matter, 45 crores was borrowed by me for a period of 5 years. My lord, the installments were designed in a way, my lord, interest and then bullet payments of principal. 5 years go by, not a single default. Last bullet payment, we say that please give us 1 more year. By this time, this controversy has also arisen. Now they don't really agree. There's no statement. Accounts given, taken back, etc. No real default. Ultimately, my lord, we say that 1.84 crores from that equipment matter has been adjusted. And in the last 6 months, we've paid possibly 7-8 crores. Today, my lord, the claim as per rejoinder in NCLT is around 8 point something crores. We, my lord, I have the rejoinder. 5, according to me, is payable as per my statement of accounts, which is here. 5 is payable. I went to NCLT and I told them that please take the 5. And we'll try to settle the matter. They said, no, I don't want. So I'm here. I want to deposit 5 crores or give him 5 crores without prejudice. This 1.84 balance is not around 3 crores. Out of this 3 crores, 1.84 crores is adjustable from the first matter. So you either give me equipment, I've even paid for that. You never gave me documents of title. So I'm entitled to this apportionment of 1.84 crores. The rest is penal interest, which is illegal. Now, this is the matter. I suggested let's go to a strong commercial mediator. Ultimately, we are fighting about 1.84 crores and that little bit of penal interest. If I can today pay him 5 crores, I can today pay him another 3. It's not that I have to go into insolvency and the arbitration will go away. So what is he doing? That first default on his part, he is carrying it forward to the loan transaction, refusing to adjust that 1.84 crores, and therefore taking me to NCLT and having me pushed into CIRP. Now there is a line of judgments, and I don't want to argue this. Lordship's inherent powers under Section 9 are wide. Using inherent powers, civil court and your Lordship, taking up arbitration Section 9 has the power to pass orders to protect the proceeding, to protect the arbitration. Now, if I go into liquidation for just cause, and the just cause is always, if there's a money claim against me, if I produce money, then I'm entitled to protection from your Lordship. Your Lordship will direct me to pay, deposit, and will pass such orders. In Singapore, orders have been passed in similar situations, restraining a party in personam from proceeding before NCLT. I have the judgment with me. I've got judgments which show that your Lordship has inherent jurisdiction to pass orders. But at this stage, I want to pay him without 5 crores, which is without prejudice to my rights and his rights. Because I want to go to arbitration in respect of both matters and have the issues thrashed out. His claim, let me show your Lordship just one document. What is his last claim? That's this is his rejoinder towards the page 3 of his rejoinder is 8.50 crores. Can you pay him? And I've paid. We have 60 crores payment. I have a 60 crore payment. I have a 30 crore prepayment in this matter. Before it fell due. Given before due dates. Now, out of this 8.50 crores, I want to pay 5 crores without prejudice to both our rights. And I want to go to a strong commercial mediator who can make both of us see sense and not start 2 arbitrations where the dispute is actually 1.84 crores. That's why he wants money. He doesn't want CIRP. So let me pay him 5 crores today and let us go to mediation.
Yes, well, this is just to say setting up one court against the other. Purely and simply is that 22nd July this application is filed. Kindly have a look at the prayers in this application. Then your Lordship will come to the prayers. So 22nd July he invokes the Section 9 jurisdiction with certain prayers. But if your Lordship kindly takes up the item number 21. The prayers. Your Lordship keeps that.
If he doesn't agree, I'll move.
Well, why I am saying this, after this Section 9 invocation, he goes to NCLT, files an application, and this is the prayer that an order permitting the applicant to tender due amount of 5 crores to the respondent or an order permitting the applicant to deposit with the tribunal. On this application, this is after my rejoinder saying 8.5. So on 8.5, he says to the tribunal, I will deposit 5. And this matter is now being contested. It is coming up for hearing tomorrow. So, my lord, in that case, he has practically, after in view of this application, he has waived his right to invoke Section 9 jurisdiction. Now, your lordship will see the Section 9 prayers in the second matter. First matter, it is only a prayer for security, which anyway cannot be granted, my lord. But kindly see the prayers in the item number 21. Whether these prayers can at all come after he has filed the application in the NCLT now. He says, direct the respondent to accept reconciled statement forwarded by letter dated July 20, that is, Lord, section 21 notice, he gives a reconciled statement. Then, my lord, alternatively, respondent be directed to provide to the reconciled statement of accounts after giving adjustments to all payments made by the petitioner. But in a section 9 court will go into, my lord, the reconciliation of accounts and reconciliation of statement, and then your lordship will see, direct the respondent to accept payment from the petitioner in terms of the reconciled statement, which according to him is 5 crores. But he has gone to NCLT and made the same prayer now. Now, my lord, kindly see next prayer, prayer E. Injunction restraining the respondent from taking any coercive steps pursuant to the notice of demand, section 7 notice. So, my lord, this prayer is completely barred under the specific relief act. There is already a proceeding invoked. You come to section 9 court, say that you accept this amount and stay the proceeding virtually. Now, my lord, you have already gone to the NCLT with this particular prayer. Now, how can you invoke section 9 jurisdiction at the same time? So, this is completely a proceeding which is now being, my lord, set up to stall the proceedings before the NCLT, my lord. But that proceeding is at the stage of final adjudication. Let that reach its logical conclusion. And these prayers, with my respectful submission, are outside the scope of the section 9. What is the interim measure in respect of the subject matter of the arbitration agreement? You are asking practically this kind of a prayer we make before the arbitrator, that there is a reconciliation of statement, reconciliation of accounts have to be gone into. You ask them to accept this amount. This, my lord, my submission is that it is covered by his own prayer, which is now being adjudicated upon before the NCLT, my lord. So, my lord, my lord, my most respectful submission.
We'll see next week. Let the NCLT take a.
No, my lord, may I just?
Yes, Mr. Chair.
Lord, may I just?
This is basically, Mr. Chaudhary, to scuttle the NCLT proceeding.
Not scuttle, my lord, to destroy it.
It is very candid.
No, my lord, to destroy it. My lord, but my lord, there is a distinction. A, my lord, you have a vexatious proceeding when somebody comes with, my lord, you try and conceal that the effect of the order which I'm asking your.
They have already refused.
Yes.
Either let Mr. Sen go and take instruction, because he's only appearing in item 21. As far as 20 is concerned.
Yes.
They have already refused.
Yes.
Your offer of 5 crores.
Yes.
Why will they accept it here?
Now, my lord, it's not for him to accept. Because he's refused, I can't go to NCLT and make the prayer. But I can come to your lordship for protection, and it's permissible. May I cite an authority? The Singapore High Court case. Lord, please see this.
Singapore.
Yes, my lord, it's possible.
A specific relief act is standing.
Yes, I'll show your lordship. My lord, please see this. And I'll show your lordship's jurisdiction.
In the context of section 9.
76,
My lord, please come to paragraph 76.
Yeah, okay, একটা দাও ভাই,
Hey,
ওটা যেটা সিঙ্গাপুর টিঙ্গাপুর আমার কাছে নেই।
You've given already.
No, I hate Singapore. I went there to Singapore.
Oh. All over.
No, no, my lord. It's possible, and yes, and my lord,
Well,
it's
not
very
in our
no,
jurisdiction.
no, my lord, it's very simple.
Let us stick to our
No,
jurisdiction.
no, I'll show your lordship. It's possible,
Let's be natives
but
and stick to our.
but when we come with a malafide prayer, it's impermissible. But when this is coupled with payment, as your lordships direct, it is possible.
But
because it's for protection of the arbitration proceeding.
Mr. Banerjee loves Singapore. He's sitting right there. Loves going there all the
But why shouldn't he wait for this his own
Because you want to put me into NCLT.
But then
and I want to pay.
Then he could file this application to the NCLT.
Now the
He
Milord,
should have waited for this application.
let's see this, Milord. If today I pay,
you want me to do this exercise, I'll allow them to file their affidavit.
Yes, Milord. Kindly.
Can't be decided without exchange of affidavit.
Yes.
but when your lordship, Milord, his sense of confidence in the NCLT,
I don't have any
instills,
confidence.
Milord, deep fear in my heart.
Where is the
Knowing
confidence?
NCLT and seeing his confidence, it
Well,
Milord instills deep fear.
He has better
Now-
knowledge than me about NCLT.
That's why I'm saying it instills deep fear.
Come back next week, we'll see what happens.
Yes, Milord, and let me file an affidavit to the.
Milord, may I?
First you take instruction.
Milord, may I just 2 minutes? Monday. But I'll go and ask for an adjournment for your lordship's adjudication on Monday.
Don't do that.
I'm being very candid.
Yeah.
I have to.
oppose the adjournment.
No, Milord, in that case, hear me for 2 minutes, Milord, 2 minutes.
You should have given the full amount without prejudice and then
So
sorted.
if that is,
He can claim 80 crores, then who will adjudicate? He could have claimed 80 crores instead of 8 crores. No?
That's not
Who
the
will
question.
adjudicate? Arbitrator will adjudicate.
So he's ready. I take it to take 8.5 crores without prejudice, and amount can be decided. And Milord, claim can be decided in arbitration. Milord, please
he
keep
has-
it tomorrow.
he has-
I'll take instructions and come. Milord, what I'll do is 5 crores I'll give him, 3.5 crores let it be in court. Let's go to arbitration and see how much you get.
Mr. Sen,
I think that's fair.
Mr. Sen, that's the amount, your amount of 8 point something
Yes.
odd crore. 5 crore.
The only thing, Milord, the proceedings cannot.
No, now you have to protect me.
Let's be fair in this. What is the point of going to NCLT if you're getting your money back?
Full 8.5.
That's what
Yes.
he's saying.
No, he's
Full
saying
8.5.
8.5 he'll deposit here, 5 he'll go
I'll give you all without prejudice to both our rights. Let's go to arbitration.
Well, let me take instructions.
Yes, yes.
Let me take
Milord, tomorrow, Milord, we'll come back. Milord, because Milord, NCLT,
tomorrow, day after.
Milord, if I get admitted in NCLT, then it'll be gone.
How can it be admitted tomorrow?
Oh, it can be.
Your application
Your
is pending.
your sense of confidence in NCLT tells
I don't
me it
have
can
any
be.
confidence at all. At all.
So then you take
Your clients, not yours. Milord, Mr. Sen and I are on the same boat regarding NCLT. Milord, day after, Milord.
tomorrow is a holiday.
Holiday. Thursday, Milord.
Thursday, Milord.
Thursday or Friday?
Friday.
Friday.
Great.
Obliged.
But your lordship did not look at Singapore.
No, let us not. I know, Milord, he's getting all this now, Singapore and all.
Not to that us. 20.
Motion item number 22.
My lord, I beg to appear on behalf of the petitioner. I am led by Mr.
Well, this is, my lord, an application for extension of time to furnish the bank guarantee. My lord, I had furnished security by way of a bank guarantee. Bank guarantee, my lord, was extended 3 times. Thereafter, my lord, the bank guarantee was, my lord, about to expire. We approached your lordship, my lord, for extension of time to put in the bank guarantee because, my lord, we were, my lord, negotiating with the bank which wanted, my lord, 125% margin money. My lord was pleased to pass an order on the 22nd of July 2026, which is at page 55. My lord was pleased to give us 3 weeks time to furnish the bank guarantee.
Yes.
Well, as is the custom, my lord, we immediately approach the registrar, my lord, for settling the terms of the bank guarantee. That, my lord, your lordship will find at page 57. My lord, the bank guarantee terms were settled without any opposition from my learned friends. My lord, that is at page 57 on the 11th of August. My lord, that is the last day of, my lord, the 3-week period that your lordships have been pleased to provide us. So, my lord, here, my lord, we are now before your lordship, my lord, the terms have now been settled. My lord, we are here before your lordship, my lord, praying for, my lord, a further extension of time to allow us to put in the bank guarantee.
Yes, Mr.
Lord, firstly, Lord, the bank guarantee, Lord, expired.
Yeah.
And as a result, as of now, Lord, there is no security.
Yes.
And Lord, your lordships extended the time on the 14th of July. They were fully aware, Lord, that they have to furnish the bank guarantee. Sorry, Lord, 22nd of July. Sorry.
Yes.
They were aware that, Lord, they have to provide the bank guarantee within a particular time. That is, Lord, 3 weeks. That is, Lord, page 56, last paragraph, second last paragraph. Now, Lord, a further 4 weeks is now being sought. Lord, the order was passed on 14 July. It seems that they had approached the registrar, Lord, 6th of July, 6th of August.
22nd July. So what kind of why the delay, Mr. Saha?
No, my lord, we had immediately approached the registrar, my lord, upon obtaining the draft of the guarantee from, my lord, the bankers. We had approached the registrar. The registrar thereafter, my lord, called for a reference. And in the presence of my learned friends, clients, learned friends, my lord, the reference, my lord, was gone into, and my lord, 11th August, ultimately the registrar
Now,
settled.
the interest has accrued, Lord, at the rate of 6%. This is pending, Lord, since 2024.
Well, that is, my lord, something that, my lord, I can't address because, my lord, we are ready to do the, my lord, section 34 application. Well, in fact, your lordship had heard briefly once, but, my lord, thereafter, the court's business did not permit the matter to be taken. We can also argue the section 34, my lord, if your lordship's time permits.
Yeah, but the security has to be provided first.
Of course, no
Yes.
doubt. No doubt about it.
Final order, 11th August.
What are these objections which have been taken before the
Well,
registrar?
now there are no objections now, my lord. Now the terms have been set.
Lordships directed, Lord, I tell your lordship why it went, because your lordships had directed that they can also file a fresh guarantee.
Right.
Now, Lord, on the mere renewal wouldn't have attracted the registrar's jurisdiction, but because, Lord, the bank guarantee had come to an end,
Right.
and obviously, Lord, they had applied before your lordship, Lord, post expiry of the bank guarantee.
Right.
Therefore, Lord, the registrar, Lord, in usual course, he draws up a proceedings for the purpose of settling the draft,
Right.
whether, Lord, it is in terms of the earlier bank guarantee or not.
Right.
And that is the reason why, Lord, it took a little time so far as the registrar is concerned.
No, only one small correction.
A renewal of the earlier terms on earlier terms and conditions, Lord, then no reference was necessary. It was just
on the 25th of
No,
July.
the bank guarantee had already expired.
Yes.
The flux of
No, that's not correct.
fresh bank guarantee.
No. They can renew that same bank guarantee or, Lord, fresh. Your lordships had given them that liberty. They are renewing the bank guarantee. Here, Lord, they are renewing the bank guarantee.
When the bank guarantee expired on 25th of July, your lordship's order, my lord, directing extension was, my lord, passed on the 22nd of July. So it's not as if the bank guarantee expired.
Therefore, it would have been a matter of course, the renewal. But because
just been done, there was no
because
need.
they didn't, Lord, renew it before the expiry, therefore, Lord, all this happened.
The reason we approached your lordship was, my lord, because of some problems that we had the bankers with regard to the quantum of margin money that they were asking for. Otherwise, my lord, we have renewed it on 3 different occasions for successive 1-year periods. There was never, my lord, a problem, and we never had to approach your lordship.
We'll give them time to deposit, Mr.
Not 4 weeks, my lord. They are asking for 4 weeks.
We'll give them 2 weeks. 2 weeks. Let them do it in 2 weeks' time. This is
Very
just.
well.
My lord, only to assist Mr. Shah.
Yes.
My lord, I have just taken an instruction. My lord, banker is in Bombay. My lord,
I don't care about your
my lord,
banker at all. This
my
is
lord,
going
my lord,
on.
no, my lord
Oh,
is much
sorry,
more
sir.
alert than me.
Sorry, no. This is going too much, far beyond everything.
Very well, my lord. I leave it to your lordship.
Necessarily taking time, just
I
delay
leave it to
things.
your lordship.
Take down. The present application has been filed by the petitioner seeking modification of the order dated 22nd July 2026 passed in whereby the petitioner was directed to furnish a fresh bank guarantee in terms of the earlier order dated 14th July 2022 within a period of 3 weeks. Full stop. Learned counsel for the petitioner submits that the terms of the fresh bank guarantee were required to be settled before issuance. Full stop. Pursuant to the order passed by the learned registrar insolvency on 6th August 2026.
11, not page 69.
Sorry.
11.
Sorry, 11th August 2026. The bank guarantee was furnished to the respondent. The respondent, the objections were furnished by the respondents, and finally, while order dated 11th August 2026, the same was settled. The terms of the said bank guarantee were settled by the registrar insolvency. Full stop. In the meantime, the order dated 22nd July 2026 had expired, and thus the petitioner has preferred the present application seeking extension of time to furnish the bank guarantee. Full stop. Having considered the explanation offered and the facts that the terms of the bank guarantee has been settled by the registrar insolvency, this court is satisfied that the petitioner has acted bona fide and that the delay in the process of the settlement and issuance of the bank guarantee is not intentional. Full stop. No prejudice shall be caused to the respondent if a short extension is granted. Full stop. Accordingly, the order dated 22nd July 2026 is modified to the extent that the petitioner is granted a further time of 2 weeks to furnish the bank guarantee in terms of the order dated 11th of August 2026.
Passed by the registrar.
Passed by the.
One request, 2 weeks from today, your lordship will kindly make.
2 weeks from today, passed by the learned registrar insolvency. Full stop.
I am very grateful.
Upon furnishing of the such bank guarantee to the satisfaction of the registrar original site, the interim order staying operation and enforcement of the award dated. What is the date?
Award is
21st of March 2022.
Shall continue in terms of the order dated 14th July 2022.
I am very grateful, man. Extremely good.
The application is accordingly allowed and disposed of.
Only seeking liberty to mention, Lord, once the bank guarantee is furnished for listing the matter, Lord, liberty to mention.
Liberty is granted to the respondent to mention the matter if the said bank guarantee is not deposited within the extended time.
Grateful.
Also, much.
Amendment application under 23.
My lord, I beg to appeal for the applicant. My lord, this is an amendment substitution application, my lord, filed due to the cause of the death of the the petitioner, my lord. When the last occasion on the matter was came up for hearing on 27th of July, when the respondent has sought for time to file opposition, my lord, till date, no opposition has been served. But I am placing one record, my lord. Another 37 application was filed by my learned friend's client before the division bench, my lord. My lord, wherein, my lord, they have carried out the substitution on the basis and the manner already we have proposed for. My lord, may I show that application of substitution filed by before the division bench, my lord?
What is this
My lord,
application?
this is an application of substitution filed before the division bench. On the, my lord, there was section 37 pending from the same award, my lord. By the between the same parties from the same award, my lord, they have substituted the petition hearing before the division bench on the same manner, my lord. Now they are opposing the application filed by the petitioner before this court, my lord.
Yes,
I'm not opposing the substitution of the petitioners in place instead of the deceased petitioner. If your lordship sees the proposed amendments at page 24, they propose to include certain respondents, also with whom I have no problem, but they have not included one respondent who's also a party in the arbitration and against whom an award has been made. Award is made jointly and severally against the respondents. So on the inclusion of the respondents here, kindly come to page 24, please, Malad.
Yes.
As far as 23 is, Malad, substituting the heirs of the deceased petitioner, there's no difficulty. I have no objection at all. This is the amendments made in that.
Yes.
How we do in the original set. 23, my lord, I have no difficulty, my lord, where they strike out the name of the deceased petitioner, implead his heirs.
Yes.
In effect, giving effect to substitution. But 24 now, my lord, kindly see 24. So 24, all the parties who were initially there, 1, 2, and 3 wants to strike out.
Yes.
And he wants to implead only 1 and 2. Now, this is where the difficulty is. It is a specific case. Now that he has narrated the chain of succession, because all this is in terms of orders passed by the Bombay High Court. Kindly come to page 7, please, my lord. Page 7, paragraph 13.
Yes.
This amendment which he now wants to bring in, my lord, substituting the names of the respondents, he says is in furtherance of.
I had given you time to file your reply, right?
Yes, ma'am, we are out of time.
You were supposed to file your reply?
Yes, my lord. To get all these papers, my lord, it took us some
My lord,
time.
difficulty is that, my lord, already, my lord, 3 weeks has passed, my lord. My lord, my pleadings is specifically made in paragraph.
Because if your lordship sees.
My lord, paragraph 8, my lord, the defendant respondent 1 and 4.
File the reply. At least I will have clarity with your reply.
Yes, my lord, because paragraph 13, my lord, it took us some time to trace these papers. These are all orders of 2012-13 made by the Bombay High Court, my lord.
Learned counsel for the
My lord, they have, my lord, kindly consider their application, my lord, on the same manner they have implemented, my lord.
That's all right. Let him file his reply.
My lord, the part portion, my lord, the proceedings be, my
I
lord.
do part portion, sir.
My lord, let the legally has been implemented, my lord. My lord, only 3 weeks.
I will pass partial orders.
My lord, 3 weeks has passed, my lord. My lord, let
That's
me
all right. I'll
restrict it,
grant
my
them
lord.
extension. Learned counsel for the respondent.
My lord, this is a
And is
dilatory
granted
tactics,
for
my
the
lord.
time of 1 week.
1 week, per I'm telling.
1 week to file their affidavit in opposition. ये होगा application में, GA3. Reply to the same if any within 1 week thereafter. List after 2 weeks.
My lord, kindly record my humble submission regarding that. They have filed an application. My lord, kindly record my
I'm
submission.
giving you opportunity to file your reply. Put that.
Yes, ma'am.
1 week. 1 week, 1 week.
Weeks. Under 24.
Yeah.
So section 11 petition, my lord, which.
ESR warehousing. Here or there, right?
Yes, yes. Here or there, correct. Whether, my lord, Delhi has the seats or, my lord, whether Kolkata has, my lord, the exclusive forum selection clause will govern the section 11. And the.
You had made you some submissions.
Yes, yes. I made my submission. I also not cited, my lord, this is Harishankar's judgment, my lord, that cars 24.
Yes.
And I want to show some more judgments on that issue.
Where he had said that he couldn't really find any precedent as such.
Yes, yes. Because, my lord, here there's a conflict. Here there's a conflict. There are 3 or 4 cases, my lord, which are on conflict. The others are, my lord, all, my lord, where there was no conflict in that sense. The word venue was used. Venue,
So that is
Supreme
the reason
Court.
why there's no precedent.
That's right. Venue, they said it is equal to seat. I have no, my lord, dispute with.
It is a settled proposition.
That's a settled proposition. No, there's no argument with regard to that. And, my lord, there's also a judgment which was delivered by my lord. There also, my lord, I didn't find this conflict arising really.
Not this. This
Not, it wasn't this. It was again, my lord, a venue and seat question.
venue and seat.
So today, my lord, 3 points we are concerned with. First, how do you look at section 21E court definition in the Arbitration and Conciliation Act? That's first. 2 is whether seat is really relevant to the arbitration proceedings itself and all proceedings connected with the arbitration, whereas the exclusive forum selection clause would have to be given a meaning in when we come to court with an application. That's the second. And thirdly, my lord, when both courts have jurisdiction, whether the principle of section 1111 would be then used to say this court, my lord, will appoint the arbitrator. Because, my lord, I would, with great respect, not find it very difficult for the court to really throw me out.
Such big companies having such a poor drafting.
I don't know what, my lord, they were. There must have been a thought behind that, my lord. I've not been able to find, my lord, what is really the thought behind that. Maybe what I'm arguing is the thought. Maybe it wasn't. But then, my lord, we just have to look at.
We just have to look at the.
That's right. That's right. Well, that's absolutely correct. Absolutely correct. Because what, my lord, strikes me, and my lord, that's my most respectful submission is, in the face of that clause, whether this court can say, I have no jurisdiction. As soon as the answer, if the answer to that question is I cannot say, then, my lord, I will have to succeed. Because that's a subsequent proceeding.
Yes.
If, my lord, the court holds no, the exclusive forum selection clause will override, that's, my lord, a different issue. Then, my lord, we are in anyway. But I'm saying, even if there's a contest, my lord, between court versus court, then I have an easier task or, my lord, a job to say, my lord, then the prior court, my lord, will have to succeed.
You filed it in Delhi.
We filed it in Calcutta. This is, my lord, my. They have, my lord, filed in Delhi.
Because of the seat.
Because of the seat, which is a subsequent proceeding. Because so far as, my lord, exclusive, if it only had an exclusive forum selection clause, then again, my lord, there's no difficulty. Then Swastik Gases, ABC Laminat, Hakam Singh, right from there, my lord, the court will have jurisdiction.
Yes.
And initially, my lord, there was a thin line, my lord, where they say if nothing arose here, then you cannot. But that, my lord, also got diluted and said no, exclusive forum selection clause means exclusive forum selection. Parties have chosen. My lord, just once so that, my lord, we know the clause again. Page 86, my lord, is the clause. Shall have exclusive jurisdiction to settle any controversy, conflict, or dispute of any nature arising out of or in relating to or in connection with any indemnity claim under the sublease deed or any other provisions of the sublease deed. Then, my lord, 22.3 is, my lord, where that, my lord, seat clause comes in. If the party is unable to resolve disputes and such, then the seat or legal place of arbitration shall be Delhi, India. Now, my submission is, my lord, that doesn't mean, my lord, that it can override, my lord, the exclusive jurisdiction clause. Then party shall bear and pay its own costs, expense and so on. Then, my lord, 22.4, my lord, it is again repeated at page 87. So twice, my lord, my lord,
Would you by this 22.1?
Yes, my lord.
This sublease shall be governed by and be constituted in accordance with the laws of India. That's fine. The parties irrevocably agree that subject to clause 22.2,
Yes.
which is if any dispute arises between the parties, they shall for a period of 15
Correct.
business days from the such date use all reasonable endeavors to resolve the dispute amicably.
Yes.
All right, that's okay. Shall have 22.2 and 22.3. Now 22.3 talks about your
The seat.
arbitration, the seat
Yes.
below.
Yes.
The courts at Calcutta shall have exclusive jurisdiction to settle any controversy, conflict, or dispute of any nature arising out of or in relating to or in connection with any indemnity claim under sublease deed or any other provision of this sublease deed.
Then, my lord, sublease deed, then dispute.
Bracket dispute.
So there is a dispute, my lord, with regard to, my lord, whether they should pay me rent.
But 22.3 itself is quite clear. If the parties are unable to resolve the dispute amicably in accordance with 22.2 of the sublease, the dispute shall be settled exclusively and finally by arbitration.
Correct.
Carried out in English language in accordance to the Act 1996 in effect from the time of such arbitration by a sole arbitrator mutually appointed by the parties. Judgment of the award shall be entered by any court having jurisdiction.
By any court having jurisdiction. That's also very important.
So wherever
by any court having jurisdiction.
It can't be against the settled principle of law. Any court would not mean any court.
No, any court means there can be more than one court. Because there is more than one court issue here.
But the seat or legal place
Correct.
of arbitration shall be.
Yes. But how do we, my lord, with great respect, my lord, if I put my argument in question form, then, my lord, the exclusive jurisdiction clause, my lord, with Kolkata, my lord, becomes redundant. And 22.4, my lord, again repeats it. So I am saying, my lord, the seat doesn't necessarily, my lord, now trump the exclusive jurisdiction clause.
Where do you get that?
Sorry, my lord.
Where do you get that? How do you get that?
That's my submission. It cannot, because otherwise, my lord, the seat clause becomes infructuous. The arbitration clause becomes jurisdiction clause becomes infructuous.
The seat is such a settled principle of law.
Yes, can be. But so is exclusive jurisdiction clause also a settled principle of law. So is exclusive jurisdiction.
Not for arbitration.
Well, for everything. That's the jurisdiction of the courts, my lord, with great respect. Otherwise, my lord, this was not necessary. Otherwise, not necessary, because
just stretching it far.
My lord, one has to, my lord, courts at Calcutta will have to be given a meaning. Otherwise, my lord, it has no meaning. That's why I said, my lord, I am before a court at Kolkata, Section 11 jurisdiction. That court, my lord, cannot throw me out because, my lord, on the face of it, I'm showing, my lord, the courts at Kolkata shall have exclusive jurisdiction clauses there. And that's why, my lord, my third argument. That's why the third argument. Any court will also result in my favor. But I want to argue, my lord, which is what the judgments hold. Saying, my lord, when there's an exclusive forum selection clause.
You are a company from?
My lord, I'm a company, my lord, in Bangalore and
so go to
Mumbai.
Delhi. Go to Delhi. Why are you so hell-bent upon Calcutta?
Because, my lord, the property is here.
It's okay. The company is not here.
Well, they want to go.
What extra do you get here?
Well, that question, my lord, no one will be able to answer. Amazon is a big company. What extra, my lord, will they get in Delhi? Nothing.
But why this academic exercise?
My lord, in fact, my lord sees Amazon, their office, I find, my lord, is Bangalore.
That's all right. But as far as the seat, I want to just understand what is the reason that they are.
Well, I think they want, my lord, arbitration, my lord. Seat or not, my lord, they want the arbitration to be
Arbitration will be-
appointment here. My lord,
I mean, you know,
my lord, I won't be able to, my lord, answer that question because, my lord, if there's a forum selection, there must have been a reason, my lord, why they had chosen that forum selection also. Otherwise, my lord, it would have only left to, my lord, seat Delhi was enough.
on the first blush, I think seat will definitely have some relevance to it.
Yes.
A lot
So far as the conduct of the arbitration proceedings is concerned. But so far as, my lord, conduct of court is concerned, with great respect, my lord, that clause has to be given some meaning. Otherwise, that clause becomes, my lord, absolutely ocious. My lord, it's nothing. Because I am before, my lord, a court which, in terms of the agreement, says will have exclusive jurisdiction.
Why don't you speak with your client and say this court is not very inclined for the exclusive jurisdiction clause?
My lord, has to be, my lord, judicially, my lord, laid down.
And that will be a exercise in itself.
My lord, they want, my lord, they want, my lord, they think, my lord, according to them, my lord, Calcutta, my lord, is the one, my lord, which should, my lord, have
Then argue.
exclusive jurisdiction. No, otherwise, my lord, it would have been easy, my lord, to go to.
That's what I was.
That, my lord, for these people, it could have been anywhere, for that matter. Why not Bangalore? Best place.
I mean,
Bangalore is the best place because they were both from Bangalore.
the only reason why this falls from me is because you know the law. It's pretty much settled as far as the seat is concerned.
If there is no contraindication.
See, it's just a contraindication. When we read it, we can read it in many ways.
Yes.
And I can read it in the way that as far as the dispute to arbitration is concerned, the seat has been chosen to be Delhi. Again, you'll have a counter view on that, but I'm just saying.
Yes, quite natural, my lord. From looking at seat, there's no dispute about that.
Right.
It says, my lord, in those seat. Now, my lord, then we'll have to fit in. Today, my lord, knows interpretation of a contract has to, my lord, try give effect to all the clauses. In that, my lord, context, courts, exclusive jurisdiction of the courts don't fit in. That's the difficulty. Seat fits in.
So you had made your submissions.
My lord, I just, my lord, shown, my lord, that cars 24. I, my lord, 2 or 3 more judgments, my lord, too.
Yes, then we'll.
My lord, the cars
Try
24.
to cut it short if it was possible, but it seems like it's not possible.
No, this, my lord, may not be. My lord, we've been, in fact, my lord, we had argued it, my lord, on the last occasion as well. It's not. My lord, my learned friend can cut it short. He can cut it short immediately. He can say, I'm agreeing to
I'm
Kolkata.
not putting that question to him.
My lord, since it came to me, my lord, I thought, my lord, it's only fair. It should go to him also.
Lord, may I come back on the next team, Lord? My notes are filed, my judgments are all there. I've got you. I have a 4 o'clock fixed, madam. That's
All
the
right.
only
So
problem.
let him finish.
Let him finish, Lord. Kindly, Lord, market part heard, Lord, heard in part.
Why? Is the roster changing?
Can, Lord. We don't know. With every new.
I've not heard anything like this.
No, I
haven't heard. Only my learned friend has heard.
We'll see.
Exclusive knowledge.
Exclusive knowledge.
I'll hear him. We'll have it. Probably this week only we can finish.
Yes, please, Lord. But any day, Lord, whenever you're there.
Yes, Mr.
My lord, kindly, my lord, look at, my lord, that cars 24. It should be, my lord, perhaps, my lord.
Yes, I have a call.
My lord, we had, my lord, in fact, on last occasion, my lord, we went.
Yes.
Just very quickly, my lord, paragraph 9, that clause is there.
Yes.
Then, my lord, paragraph 19 onwards, my lord, the discussion, my lord, happens, my lord, with regard to exclusive forum selection clause and all that. Then, my lord, paragraph 40 straight away.
Yes.
Paragraph 40, my lord. 40, 41. Then my lord, three is the argument. Forty-eight.
What is this, the terms in there where the with respect to the appointment of the arbitrator was also there mentioned in terms of the exclusive jurisdiction?
Yes. Here, my lord, the
That-
clause was section 11.
That's a distinction.
No, my lord, with great respect, my lord. If the seat is there, it doesn't matter. If the seat is fixed, then my lord, all applications, my lord, will have to go there. So that distinction, my lord, will not come into play with great respect, my lord, so far as we are concerned.
See, if you read 9:25.4, parties have agreed that all disputes arising out of this deed shall be referred to a sole arbitrator who shall be mutually appointed by the parties, failing which either party may approach a court of competent jurisdiction at Haryana.
Yes.
For appointment of the arbitrator,
Correct.
sole arbitrator. This is exactly what the distinction is. And that is the reason why the exclusive jurisdiction has been given priority over
No, my
here.
lord, with great respect, the last portion of that. If you kindly read, my lord.
The arbitration
award-
proceeding shall be conducted.
Son,
The
sir, sir.
award of the sole arbitrator shall be reasoned, which shall be final and binding on the party. It has been further
Agreed between the
shall be
parties.
conducted in English, and the seat of arbitration.
Seat with New Delhi, India.
Different.
So seat is my lord,
No.
here also seat. So that argument.
What really played in the mind of the court was the sui generis approach to the fact that the appointment under section 11 would be literally in the competent jurisdiction, the exclusive jurisdiction, and that is why he has been able to.
I will show other cases also. This is my lord, but with great respect, my lord, if my lord that distinction is really not a distinction.
Actually, it can.
No, because if the seat is fixed, then any application, my lord, according to court, will be, my lord, at the seat jurisdiction. That will be overridden. Just because, my lord, it says section 11 will apply.
See, all the judgments talk about the seat. All right. The only distinction which this judgment in particular talks about in 48, if you read this position would stand underscored in a situation such as the present one, which appears to be sui generis, in which the exclusive jurisdiction clause is not generally worded qua all disputes under the agreement, but is specific with respect to appointment of the arbitrator.
Correct.
which is specific with respect to section 11.
Correct.
That is the reason.
Then, my lord, kindly see the view. My lord,
Referring to the
in
said
this
section-
judgment, my lord, that's
that
the
is
learned judge could. I'll show other judgment, but my lord, that is not a distinction, my lord, which will apply. Because very important, after that, my lord, will see the view that the seat of arbitration clause has to be treated as akin to an exclusive jurisdiction clause has been expressed by the Supreme Court cases when there is no separate exclusive jurisdiction clause conferring exclusive jurisdiction on courts located elsewhere. Where such a separate exclusive jurisdiction clause conferring exclusive jurisdiction on courts other than the courts having jurisdiction over the contractual seat of arbitration exists, it may not be proper, in my view, to grant pride of place
this will
to the
open a
seat of arbitration clause.
This will open a Pandora box, Mr. Banerjee.
No, my lord, they are unique. These cases are unique. It's not a question of opening Pandora's box.
One is this. What else?
I'll just, my lord, may I just, my lord, complete, my lord, this 40th, then, my lord, sees over the exclusive, the middle, my lord, none of the decisions Supreme Court cited above. So the position would stand underscored in a situation such as the present, which appears to be sui generis, in which the exclusive jurisdiction clause is not generally warded, where all disputes under sunset, especially reference to appointment arbitrator. This is, my lord, what my lord is saying, but this is, my lord, the principle. Then 49. Having so observed, I hasten to clarify that I am not proposing to venture any final opinion in appropriate forum before which any challenge to the arbitral award that came to be passed under section 34 would have to be laid. This aspect, strictly speaking, does not arise for consideration, would have to be examined before which sees section 34. Then, my lord, refers to Mankastu. Then kindly see, my lord, 51. In Mankastu, Impact's place of arbitration was contractually fixed at Hong Kong. In that case, clause 17 of the memorandum of understanding between the parties which provided for arbitration for resolution dispute between them read thus. Then kindly see this MOU is governed 17.1, governed by the laws of India without regard to its conflict of law provision. Courts in New Delhi shall have the jurisdiction. Then any dispute, controversy, difference or disputes and such, validity and such shall be referred to and finally resolved by arbitration administered in Hong Kong. Place of arbitration shall be Hong Kong. Then number of and then it is agreed, party seeking. Then number 52. Issue it before the Supreme Court was with respect of the courts having jurisdiction to entertain a section 11 petition as in the present case. Supreme Court held that the fixing of Hong Kong as the place of arbitration resulted ipso facto in Hong Kong becoming the seat of arbitration. On the attention of the Supreme Court being invited to clause 17.1, which conferred jurisdiction courts in New Delhi, respect to MAQ, Supreme Court MOU, the Supreme Court observed para 25 and 27 report thus. Clause 17.1 of the MOU stipulates MOU is governed by the laws of India. Courts in New Delhi shall have jurisdiction. The interpretation to clause 17.1 shows that substantive law governing the substantive contract with the laws of India. What's in clause 17.1 without regard to its conflict of laws position, courts and jurisdiction of jurisdiction has to be read along with clause 17.3 of the agreement. As per clause 17.3, parties have agreed. Party may seek provision, injunction, or equitable remedies of a court having jurisdiction before, during, or after the pending arbitral proceeding. Then Balco Malad is discussed. Then Malad, kindly see paragraph 53.
This was also against.
No, court's exclusive clause, court was given effect.
No, this judgment of Mankatsu is also against. What said that Hong Kong would be the seat of arbitration?
Yes.
So it's not. It doesn't go in your favor.
No, then section 11. Section 11, Malad, is New Delhi.
Section 11.6, the act is not maintained, petition is dismissed.
No, as such, Supreme Court held that once the seat of arbitration fixes answer, the interim required to vacate it. Western courts in New Delhi. So 11 was there, 9 was also given effect to.
No.
9 was, I'm saying, Malad, the exclusive jurisdiction clause has to be, Malad, read into this. Otherwise, Malad, I can't put that clause anywhere. It becomes meaningless.
Low PTO.
Here, Malad, in the cast 24, the additional thing was there with regard to section 11. And so far as we are concerned, it only says, Malad, exclusive jurisdiction, Malad, is, Malad, with the Kolkata courts.
This is entirely, you're reading it entirely differently, Mr. Banerjee.
Malad, I'm only reading it.
Being read by this court to give effect to the fact that section 11(6), the Hong Kong would be the court of exclusive jurisdiction, because that is how the terms of the
That's right.
yes.
But section 9 is a
Section 9 also, the court said we are not interfering in section 9
because New Delhi also is, that clause is also given effect to. That's all I'm, Malad.
the reasoning which has been given in this judgment is to give effect to the fact that the exclusive jurisdiction was to the Hong Kong court. He has imported the same proposition and put it here to argue the point that since the exclusive clause for appointment of the arbitrator is given, and that is the reason why the distinction.
Let us, Malad, take it like that. Malad, courts at Kolkata have to be given, Malad, some effect.
If it was mentioned,
Malad is reading down. No, to fit into this case, Malad is saying only if it was mentioned that for 11, section 11 appointment, then I would have given effect to, otherwise no.
Or arbitrator, anything to do with 11, arbitrator, any word like that. The exclusive jurisdiction which you are talking about in terms of the courts of Calcutta having it.
Malad, let me put it this way. Malad, I've understood what Malad has solved. Malad, let me put it this way. This case is good for the proposition that seat concept does not take away a country jurisdiction clause. To that extent, Malad, may I just, Malad, put it that way?
All right.
The seat clause doesn't take away the possibility of there being another country jurisdiction clause. Now, in this case, Malad, it says section 11, competent court is Haryana. In our case, it says courts at Kolkata shall have exclusive jurisdiction. To that extent, I don't want anything else, Malad, from this judge.
If I hold this today, I'll be flooded with section 11 applications in this court. Flooded.
Great respect, Malad. These are, Malad, very unique cases where they have get into this controversy. Malad, either, Malad, it's an exclusive jurisdiction clause or, Malad, it's a seat clause. They don't have both together. There are very few matters where, Malad, both are together like that. And it is analyzed. Malad, BGS, Soma, Malad, all the other judgments. We only have.
BGS, Soma and all is very clear to the extent.
Correct. But there was no conflict. We have, Malad, about 4 or 5 cases on conflict, including, Malad, the height insurance, which, Malad, I think, Malad, they showed it got disposed of, Malad, without, Malad, there being, Malad, any pronouncement on the law. That's what you said last.
That's exactly what I was trying to do.
No, but we are not, Malad, willing to.
I know you're not.
Height insurance, Malad, I was there, Malad, successful in, Malad, in that matter. There's, Malad, I'll show, Malad, there's our courts, Malad, which have held to the contrary. There's Justice Saraf, Malad, who's held to the contrary. Giving effect to the, Malad, for exclusive forum selection clause. Because concept of arbitration, yes, no difficulty. Though, Malad, this was an international commercial arbitration concept, Malad, which got imported, Malad, into the Indian domestic concept. Seat was never, Malad, a part of, Malad, domestic arbitration ever.
I'm just thinking if you were on the opposite side, what would have happened in this case?
Malad, the court would have been with me. Now, Malad, the court is against me. I'm trying to, Malad, argue my matter. And, Malad, there is a case, Malad, which kindly, Malad, considered. Otherwise, Malad, the difficulty, Malad, which I have is, Malad, on that, then that clause becomes.
That's right.
And here, Malad, there are no 2 section 11s. Here, Malad, there are 2 section 11s. Because in spite of that clause, Malad will have to then hold against me to say that, no, I do not have jurisdiction. In spite of that exclusive jurisdiction clause. Malad, but Malad, this is, Malad, what this then, Malad, kindly come to. Malad, this is a judgment, Malad, of our courts. Which applied under this is section 9 of the arbitration conciliation. Learned counsel may raise objection. Submitted parties enter into leave and license agreement. Referred to clause 16.7 of the leave and license agreement dated July 11. Submitted since the parties agreed. That says that the seat of arbitration shall be in New Delhi. The courts in New Delhi has exclusive jurisdiction to try and determine any proceeding under 1996 Act. Support of this contention relied upon the order dated Sansach, Delhi High Court in Sansach, Devyani International, then Munot Construction, Aishundara, Sinopolis, then transfer petition, then all this will relied upon. Learned advocate appearing for the respondent 4 has submitted that clause 16.6 of the leave and license agreement dated July 11, 2019 does not affect the choice of jurisdiction of parties. He has submitted since the parties agreed to the seat of arbitration in New Delhi. Clause 16.6 did not have overriding effect on clause 16.7. Learned advocate appearing for the respondent taken the point of pecuniary jurisdiction, courts allowing jurisdiction subject matter. Then my lord, kindly turn over the page and kindly see seven. Learned advocate appearing for the petition referred to clause 16.6 and 16.7 of the leave and license agreement dated July 11, 2019, submitted that when the parties selected the forum for adjudication, then such selected forum will have precedence, notwithstanding the parties have agreed that the seat of arbitration will be at a different place. He has submitted when there is a conflict between the forum selected by parties and the seat of arbitration. In the case of domestic arbitration, then the forum selection clause will prevail. Support is a contention and learned advocate appearing for the petition relied upon section 2.2 and section 9 of the Act of 1996. He has submitted that the seat of arbitration, venue of arbitration, a concept borrowed from international arbitration law, referred to and relied upon the swastik gases, Mankastu, Brahmani river pellets, and then Cast 24. Cast 24 also referred. Then learned advocate appearing for the petition relied upon I-59 Supreme Court, Radha Sundar Datta. Then my lord goes on, then kindly come to paragraph 13. Parties have relied upon section 22E and section 20 of the Act of 1996, which are as follows. Then my lord, that is set out. Then my lord, kindly come to paragraph 15. Parties have not disputed the existence of arbitration agreement. According to the petitioner, courts at Kolkata shall have exclusive jurisdiction to try the dispute of any arising out of or in relation to the leave and license agreement dated July 11, 2019, view of clause 16.6 thereof. On the other hand, respondent has contended that since the seat of arbitration has been prescribed in clause 16.7 to be at New Delhi, courts in New Delhi shall have exclusive jurisdiction. Paragraph 15, my lord. That's my lord, squarely, my lord, the issue here also. Then my lord, 16. (17), 18, 19, 20, and my lord, the 27, my lord, are the issues. (27) onwards, this my lord considers.
Roman 4.
Correct.
That's what your answer is.
Yeah. That's why seat, my lord, really, because one has to give effect to the other clause.
Section 9, right?
Yes. But it's the same, my lord. I don't think, my lord. In fact, section 9, my lord, will be even tougher than, my lord, section 11. Because there the question of section 42 may have an application. In section 11, 42 will not have an application, which is cast 24.
All right.
So the issue is this, whether, my lord, and particularly, I'm sorry, my lord, I know my lord has read through the whole thing. My lord, 29.
You have SEC? You're reading for SEC, right?
Yes, my lord, I gave
Yes, yes.
SEC, my lord.
Yeah, 29.
Paragraph 20. SEC.
Party autonomy.
Yes. So both has to be, my lord, then if I choose seat, then I've also chosen exclusive forum selection clause, both parties. And then, my lord, (33). This distinction is very important.
Not helpful for you.
No, 33. Paragraph 33.
Only for the commercial
No,
international
why I'm
arbitration,
saying,
but the moment you talk about a domestic arbitration,
Lord,
it's not helpful. The second aspect, the second limb of the
because this is a domestic arbitration. The seat, my lord, has relevance because how was, my lord, seat equated? My lord recalls, my lord, how did seat get equated? Venue, seat, because they were considered to be an exclusive jurisdiction clause. When there's no other indication in the domestic sense, they were considered to be the intention of the parties as an exclusive jurisdiction clause. Now we have an exclusive jurisdiction clause. My lord recalls, my lord, Balco is the first one, my lord, which came with this concept. International arbitration, my lord, Kaiser and Balco, my lord, completely international. Then, my lord, all the judgments. Then they said venue of arbitration such. Then the Honorable Supreme Court interpreted said venue means we will now consider the seat.
Yes.
Why? Because then they were considered that you wanted to go to that court. It became like a section 20 of the CPC, like a swastik gases and ABC laminate.
That's what Justice Basak has held, section 20 of the CPC.
That's right. That's right. Then they were equated to a forum selection clause. But here, when there is
which has been given by Justice Basak.
This is a possible way of looking at rather this is and the facts are exactly same.
Where the parties have selected a seat of arbitration which is in conflict with the jurisdiction of the court. So he had given 4 scenarios.
Yes, correct.
The 4th scenario is attracted. It's your scenario.
That's a 4 is the one, Malad. And can you see, Malad, with great respect, Malad, to Malad, where can you see 1, 2, and 3? It makes
1, 2, 3 is clear. So
clear, correct, correct.
4th scenario is the
where
one
the agreement does not prescribe the seat of arbitration, parties have not selected any court to try the dispute, then the court having jurisdiction subject matter, very well. This is Malad complete section 20, section 21E. where the parties to the arbitration prescribe the seat of arbitration, such agreement does not have a forum selection, then the court having jurisdiction of seat will have jurisdiction try the arbitration petition. Then it really becomes an exclusive forum selection. Then where the parties prescribe the seat as well as select a forum, there's no conflict between the two. Then the court having jurisdiction, this is that Brahmani, Pellet, Bombay, where Mumbai, both jurisdictions is Mumbai. Then 4 is where we come. And 40 also, what I said, that the principle saying that every part of it may be brought into action.
Part cause of action.
That's right. Because otherwise, that exclusive forum selection will completely ignore it. Kolkata will have no relevance at all.
All right. The rest you can on the next.
Yes. Oh, sorry. I didn't realize.
Day after?
Wednesday, I think, is a holiday.
Oh, yes. Friday?
Holiday. Friday.
Friday. Third, run it senior counsel. But not go back. Let's go further here.
Delhi, it was raining a lot, I think.
Yes. Fortunately, I could take my flight.
The other flight, which was going from here, got delayed.
He's already passed the order.
Yeah,
My lord. My lord, did we mark part of
Friday? What exclusive information?
No, my lord, it was heard at length before the.
I have no difficulty at all, kindly.
No, my lord, it was heard at length before the prior court. That's why we're just trying to make sure that this time it's completed.
Grateful.